Straight ahead on Law and Crime Daily.
It is never too late to get to the truth.
The daughter of a man executed for murder is calling for new DNA testing in his case, but prosecutors say it shouldn't be allowed.
At some point, this must end.
Should rioters in the deadly Capitol insurrection be accused of organized crime? Our experts weigh in on possible new charges.
There is no way that the Proud Boys and the 3%ers and those other organizations operated in a vacuum.
Plus, the police interrogation of the woman charged with helping to cover up the murder of a mother of 5. Michelle Troconis says she's innocent in the death of Jennifer Dulo, executed.
It's very overwhelming. I feel like I'm being pulled in 1,000 different directions.
That was April Alley in 2019 after she first petitioned the state to retest evidence in her father's case. Alley was just 9 years old when her father, Sedley Alley, was arrested, later convicted, and then executed in 2006.
Watching my father die was so painful that I'm hoping I can get the answer, one way or the other, that I want.
Alley believes her father could be the first person proven innocent by DNA testing after their execution. Sedley Alley was found guilty of the rape and murder of Marine Lance Corporal Suzanne Marie Collins in 1985. Police say Collins was out jogging when she was abducted, tortured, raped, and left for dead. 2 Marines pointed out Alley's car as the suspect's vehicle, and he even confessed to the crime. But attorneys with the Innocence Project say his story doesn't line up with the evidence and offer another possible suspect.
We had an investigator, we hired a private investigator who went out. She discovered that Suzanne Collins had a boyfriend in Memphis and a fiance in California. And the boyfriend in Memphis didn't know about that fiance in California. But she was getting ready to end that relationship in Memphis to go back to the boyfriend. That boyfriend drove the exact same wood-paneled station wagon that was described as the vehicle that abducted Suzanne Collins. And he matched the description of the person who abducted Suzanne Collins.
The Innocence Project wants a pair of underpants worn by the attacker as well as the victim's bra and socks tested for DNA. The items are sitting at evidence in a clerk's office. Prosecutors, however, say Alley had enough time to appeal his case when he was still alive.
Twice, post-conviction courts took up his petitions and they gave it a full analysis, and they said he did not meet the 4 statutory factors. Twice, this court looked at that, gave full decisions, full and thorough decisions about why those decisions should be affirmed. Twice, the Tennessee Supreme Court looked at that and declined review from a Rule 11 application. Twice, the U.S. Supreme Court reviewed the petitions for writ of cert that were filed about this, and twice declined to grant review. So there was a full opportunity, multiple full opportunities afforded to Sedley Alley regarding DNA testing. And due process does not compel this court to say, well, he should have yet another one.
Lawyers for the Innocence Project made their arguments for post-conviction relief on behalf of the defendant's estate.
The state argues that its own actions in executing a convicted defendant extinguish not only a life, but any claim for access to evidence in the state's exclusive possession that might demonstrate that the state has executed the wrong person. That cannot be right. If the state had adopted a policy of automatically destroying all DNA evidence concerning a crime, including trial exhibits that would otherwise be kept indefinitely, immediately after an execution, it would be an obvious injustice and due process violation. But if the state cannot destroy evidence just because it's executed the defendant, then it makes no more sense for the state to be able to cut off access to the same evidence just because they've executed an individual.
Joining us is Law and Crime host, attorney, and expert on cases like this, Linda Kenny Bodden, along with defense attorneys Imran Ansari and Terry Austin. Linda, you've been passionately following this case. What should we be focusing on here?
Okay, so let's remember this. This case was in 1985. that this defendant was convicted, the person who's now seeking DNA through his daughter, through the estate, right? There wasn't even DNA that was used in the courtroom anywhere in the USA at that point. So there was no opportunity to use DNA then. When the chance came later in the 1990s to use DNA, the courts in Tennessee said, you, Mr. Sedley Alley, you can't get it. You know why? And let me read it to you because it's mind-blowing. That there's not a reasonable probability that you wouldn't have been prosecuted or convicted if the tests were in your favor, okay? So that was denied. Then later on, when he sought again DNA testing in 2006, I believe, 2004, he was executed in 2006, the court said, well, you can't put it into the CODIS database, so we can't give you DNA testing. So what the state is basically arguing is that because we screwed up along the way, you are now not a person because you're dead under the DNA testing statute to get DNA. And that's where this case lies today. And that's where these judges on the appellate courts are deciding whether or not Sedley Alley's estate, through his daughter, is a person to get DNA testing now.
I mean, Imran, especially taking that information, what do you make of the prosecution's argument that Alley's time to appeal has come and gone?
Yeah, Brian, you know, the prosecution is really taking a stance on a procedural ground in terms of arguing that this appeal process is not appropriate at this time. You heard the prosecutor going through all the attempts to get this reviewed before an appellate court. He talked about certiorari being denied. That means that the appellate court, that specific appellate court, denied to review this conviction. And, you know, they're really hanging their hat on this procedural argument, saying that time has passed procedurally and all the appellate opportunities to get appellate review have been exhausted, and that's why this one should be denied.
All right, Tara, you listened to the arguments on the appeal. How do you think the court would rule here?
Well, I hope the court should rule in favor of Alley, and here's why. This is a person, whether the person has passed away or not, and the real public interest reason why the court should rule in favor of Alley is the fact that with this new DNA evidence, we can find out who the real killer might be.
All right, we'll see if this DNA evidence does get tested and we can figure out who the real killer is. Thank you all for your input. Still ahead on Law and Crime Daily, a former police officer charged with murdering a man in Ohio makes his first court appearance. Plus, what new charges federal prosecutors. A former Ohio police officer charged with murdering a man pleads not guilty as the judge sets his bail at $3 million. To a non-emergency call. Hill was in his friend's garage at the time. Coy's attorneys say he thought Hill was armed with a gun, but he actually was holding a set of keys. The feds have arrested more people this week for the attack on the U.S. Capitol. Law and Crime's Angenette Levy is here with more on my home country's labeling of this group involved.
Canada has declared the Proud Boys, a nationalist group, a domestic terrorist organization, as another member here in the United States faces charges for the Capitol riot. USA! USA!
Nearly a month after rioters stormed the U.S. Capitol, federal agents are arresting more people on serious charges.
The U.S. Attorney's Office and Maine Justice are now focusing on the broader contours of January 6th and the attack on the Capitol, as well as the events that occurred way before January 6th and also events after.
Gene Rossi is a former assistant U.S. attorney. Peter Schwartz of Pennsylvania faces a list of charges. Agents included photos of a man they say is Schwartz spraying an orange substance at police officers. Ethan Nordine of Washington State faces several charges, including aiding and abetting injury or depredation against government property. Nordine also goes by Rufio Panman, and screen grabs show him appearing on the conspiracy theory website InfoWars. He is a member of the Proud Boys.
The Proud Boys is an organization, it's an enterprise that could be charged under the RICO statute, and its whole goal basically is this. They hate everybody but themselves.
The leader of the Proud Boys, Enrique Tarrio, told Sky News there will be more violence if the group's demands are not heard. And Rossi believes the group may have been assisted by the Trump campaign, which could mean criminal charges for those involved, including the former president if the evidence is there.
The people who stormed the Capitol were puppets, and they were puppets of a person named President Donald Trump.
Also this week, so-called QAnon shaman Jacob Chansley was moved to a jail in Alexandria after claiming he lost 20 pounds after not being fed organic food at another facility.
I got to give his attorney credit. That took a lot of guts to file a motion with a federal court judge in D.C. and say my client's rights are being violated because he's not getting organic food.
And Gene Rossi believes that federal grand jury investigation could take at least a year. For Law and Crime Daily, I'm Angenette Levy.
Thanks, Angenette. Back for analysis are lawyers Imran Ansari and Terry Austin. Imran, racketeering, influence, and corruption organization. What does RICO charges mean for those Proud Boys charged, and how strong are the government's claims?
Sure. Well, Brian, the government would have to make sure that they have a pretty airtight, solid case in order to make out the RICO charge. RICO charges are very stringent in terms of the elements that are needed to be proven by the prosecution in order to hold a RICO charge. They would have to prove that the Proud Boys were a criminal enterprise and that there was a pattern of predicate criminal acts to constitute a RICO charge. They would have to show that at least 2 or more other incidents aside from the Capitol riot were criminal, and they were part of this sort of criminal enterprise of the Proud Boys. And it's going to be a real, the government's really going to have to do their homework. They're going to have the evidence, because RICO charges, when you bring them, often face a motion to dismiss, so they need to have the right evidence.
Now, Terry, with Canada labeling the Proud Boys domestic terrorists, does that bring any pressure on America to do the same, or do you think they should be labeled the same way here in America?
Brian, I think your home country, Canada, is leading the way here, and it will have some influence on the United States. Jen Psaki just literally at a press conference said they are considering whether or not they should label Proud Boys as terrorists. And so these groups are active around the world, and I think that we have to make a concerted effort to make sure that we quell their activities. And naming them as a terrorist group will help do that, because you can't associate with a terrorist group.
RICO, Capitol insurrections, and now a potential labeling as a domestic terrorist group. We'll make sure to keep eyes on the Capitol riot arrests. Thank you both. Coming up on Law and Crime Daily, the scary message. Welcome back. Let's check in on some of the top true crime stories of the day. Terry Austin has the latest on alleged thieves trying to make off with a big haul.
Brian, police video showing a group of people breaking into the store. The thieves ransacked the shop, grabbing 12 wallets and 32 handbags worth $160,000. The store's security guard reportedly confronted one of the men, who claimed to be armed, saying she too was armed. Police say the thief responded saying, "What are you going to do? Shoot me?" They made away with the loot into a waiting vehicle. Police believe the same suspects are responsible for burglaries in at least 20 high-end retail stores throughout Manhattan. And in Texas, authorities are apologizing after an Amber Alert describing the suspect as the Chucky doll was mistakenly sent out. The message read, "Abducted child Glenn, age 5 years old. Suspect Chucky, age 28 years old, wearing denim overalls, wielding a huge kitchen knife. His race was listed under other as doll." It was, of course, a reference to the horror film featuring the infamous evil doll. The Texas Department of Public Safety said the alert was a test malfunction.
Terry, as a child of the 80s, Texas had scared me for just a moment. I was like, are we sure this is a joke? What did you make of this doll-sized mix-up?
You know what, Brian? I want to know whose idea was this. Why couldn't they just say Jane Doe? Why did they have to use such a horrible image? I think it probably scared a whole lot of people, not just you.
Yeah, Jane Doe, and we can also probably remove Chucky altogether as well. And in Florida, one suspect was hoping his flattery would help him get a lower bond with a judge. Imran, listen to this next clip and let me know if you'd recommend this strategy for one of your clients.
So that brings us to Mr. Demetrius Lewis on page 26.
How you doing? How you doing?
All right, I'm good, sir. How are you?
Judge, you is so gorgeous, Miss Judge. I just have to tell you, you're gorgeous.
Thank you, Mr. Lewis. All right, Mr. Lewis, flattery will get you everywhere, but maybe not here. The court finds probable cause on count 1, burglary, occupied dwelling, unarmed. Count 2, possession of MDMA ecstasy. The court is going to set bond based on the priors in this case, his priors and the facts of this case. The court is going to set bond of $5,000 on count 1. The court will ROR Mr. Lewis on count 2.
I mean, Imran, for the record, the prosecutor asked for $75,000. The judge set $5,000. So maybe it worked. What do you think?
Yeah, Brian, maybe it worked, and knocked off $70K off that bail. So would I recommend that to my client? Well, I would say know your judge. There's some judges who would take offense to that sort of conduct and that arguable, disrespect in court. But then there's judges like Judge Blackman here. I think she's a little lighthearted. She saw the humor in it all. I think she was a little flattered. And who knows, maybe it worked for this defendant. And, he's at, 5K bail instead of 70.
Now, Imran, I want to ask you which judges you could do this in Brooklyn, but we've got to head out real quickly, so I guess we can't find that out. But thanks for the input there. When we come back, we take you inside the police interrogation room as detectives press Michelle Troconis. A Wisconsin man is serving life in prison for a double murder and kidnapping. Law&Crime's Jesse Weber digs into how a young girl was able to free herself on his new show, Prime Crime.
Thanks, Brian. Coming up on Prime Crime, we're going back to the abduction of Jamie Kloss. This was the girl who was taken from her home after her parents were brutally and viciously murdered right in front of her. We'll start with the police body cam and dash cam tapes as officers responded to the crime scene, and then we're going to get into the dramatic 911 phone calls, including one that took place during the attack.
Sharon County 911, where's your husband? Hello?
And since we just passed the 2-year anniversary from the conclusion of this kidnapping, we take a look at what happened and what's next. Tune in to Law and Crime.
Attorneys for a woman accused of helping her now deceased boyfriend clean up a murder want her charges dismissed. Michelle Troconis is facing charges of conspiracy to commit murder and evidence tampering in the disappearance of Jennifer Dulos. Dulos was reported missing in May 2019, and her body has never been found. Police became suspicious and then arrested her husband, Fotos Dulos, along with his girlfriend, Michelle Troconis, and friend, Kent Mahoney. Fotos Dulos died a year ago of an apparent suicide. Troconis' lawyers say evidence proves police lied to obtain warrants and released this clip of her interrogation.
We think of information.
I don't know, John, but I can walk all world with you if you want. I can take you to like a motor place. I can walk, I can spend a month with you guys. I can do whatever you want, but I didn't do it.
So Imran, like I said, the defense released part of the interrogation to show, quote, falsehoods, reckless disregard of the truth, and omitted material facts in order to get the case dismissed. How does the video help their argument, though?
Yeah, Brian, I think the video does help their argument when you juxtapose it on what was in the materials that were used by law enforcement to effectuate the arrest and the basis of the warrant. So anytime there's a contradiction between the information in those paperwork and that paperwork and what we're seeing in the video and other material that the defense is putting before the court, that really will support their argument. And I think this video does raise some questions.
Now, Terry, they released this to the public. This wasn't done in front of a jury. So do you think it was a smart move releasing the video to get this case dismissed?
I do. I mean, I think releasing it to the public is really going to affect what the public is thinking about this case. First of all, you see her, and throughout the entire video, she's crying. And some people might look at that and say she's being very sincere. The other issue is over and over, she's repeating the fact, I didn't do it, I didn't do it. So I think her testimony here is very consistent. And ultimately, if it is something that the jury sees, I think they're going to look at her as somewhat sympathetic. And I do think, actually, it was probably a smart move.
Imran, really quickly, could this be a way the defense is trying to, I don't want to say taint the potential jury pool, but to maybe influence the potential jury pool a little to say, hey, have some sympathy for her?
Absolutely. And that's also always a consideration in a high-profile case, how it plays out in the court of law, but equally as important most of the time is how it plays out in the court of public opinion. And I think the defense had that in mind.
All right, so maybe they're playing both in the actual court and the court of public opinion. Makes sense. Imran Terry, thank you very much. And thank you for joining us here at Law and Crime Daily. We'll see you next time as we discuss justice in America.